Okay, I want to welcome everyone to the webinar on business continuity and disaster recovery planning for registered investment advisors. This is Steve Parker. I can't quite tell how many people we've got joining us so far, but hopefully the people who have signed up for the live webcast are on today. Let me let you know that if you have questions you'd like to submit during the broadcast, you should be able to type them in using your username, and they should appear as a question submitted via group chat on the YouTube channel. Hopefully I can see them, and I can either respond to your question or somebody else will do so. I'm pleased to let everybody know that I'm joined again, as we were in October at our live seminar, by Nuala Zaharis, who's the director of the Securities Division for the state of Georgia. Nuala, can you hear me all right?
Yes, I can.
Okay, and I believe your sound audio level is good as well. We're very delighted that Nuala was able to join us, especially on short notice. And she's going to have some insights from what Georgia is seeing at the state level, both probably on its own and also in coordination with the other states through the North American Securities Administrators Association. Nuala, feel free to jump in at any time as we go through this.
Okay, let me just add real quickly our standard disclaimer, if that's okay.
Yes.
That the Security Division of the Office of the Secretary of State, as a matter of policy, disclaims responsibility for any private publication or statement by any of its employees or former employees. The views expressed in this presentation are those of the speakers and do not necessarily reflect the views of the Office of the Secretary of State, the Commissioner of Securities, the division, or its staff.
Thank you. It wouldn't be a securities law seminar without that.
Exactly. I'm sorry I have to say it.
No problem. Thank you. Let's move through this. Let me say just another thing by way of introduction is we do have several people joining us live today, several firms. I believe most, if not all of them, are SEC registered firms, but we have already had signed up to review the archived recording of the webinar, several state registered firms. We're about at 50-50. So we're going to cover both state and SEC principles in this slideshow. The good news is the guidance and the rules, the SEC, NASA proposed rule, which some states have adopted, and the SEC proposed rule, which has not yet been adopted, are very similar in their content. And so most of the guidance given by both the state and the SEC are overlapping and, coextensive, or pretty much the same. Look, by way of background, the idea that RIAs should, as a matter of sound policy, adopt policies and procedures relating to business continuity and business transition is something that has been around for a number of years. I'd say it really came to a head in the 2002-2003 timeframe at the beginning. Some of the major events that led the regulators to take a closer look at this issue are listed on this page, of course, beginning with September 11, 2001. The terrorist attacks led to closure of the equity markets for 4 days, the bond markets for 2 days, and several other major disruptions, as you may recall, of course. And sometime thereafter, the SEC, the Federal Deposit Insurance Corporation, and other financial regulators did an in-depth analysis of the effect on the industry and published a report which they called Lessons Learned, and that's one of the formative documents on how the current policies came to be. The next major event was Hurricane Katrina, the aftermath of which the SEC did a further survey of affected firms, and they published another compliance alert in 2007 advising firms to pay attention to these issues. In 2012, Hurricane Sandy, and particularly in its location proximity to the New York City and the financial markets hubs, caused even more widespread disruption, causing the equity and the options market to be closed for 2 days. So that resulted in another investigation or examination jointly, this time by FINRA and the SEC's Office of Compliance Investigations and Examinations, and resulted in another publication called the Joint Statement Regarding Best Practices. You can find all of these reports online, and we'll be glad to send anybody a link to them if they would simply wish to email us asking for that. Very interesting event happened in 2015 when really billions of dollars were impacted by a technology failure that occurred when one of the third-party vendors working with the Bank of New York, Mellon, was unable to provide data sufficiently to calculate the net asset value for thousands of mutual funds, and it caused a significant uproar and dismay in the markets, and that led to further investigations and additional suggestions and recommendations by the regulators. The rules that have been in place for some time and which led to the more specific rules which we have now are these. You've got the Rule 38A1 under the Investment Company Act, which has been around since 2003. This really applies to mutual fund and mutual fund complexes. But the adopting release in 2003 made it clear to mutual fund complexes that they needed to make provision for how to deal with significant business disruptions. Of course, Rule 20647, which is the general compliance and supervision rule applicable to all SEC registered advisors, was adopted in 2003. The rule itself doesn't mention business continuity or transition planning, but was interpreted from the beginning to require firms to address that as part of an overall sound compliance regime. FINRA adopted a rule in 2009 that specifically required FINRA member broker-dealers to establish and maintain business continuity plans so that they could meet their obligations in the event of sudden business disruptions. And then more recently in 2015, now we're getting into the near-term period where the regulators have been a lot more specific about what they expect to see. NASA, on behalf of the state securities administrators, adopted a model rule, which of course is a rule that the states are free to adopt or in its own form or to modify. They can do it by rule, they can do it by amendment to their statute, but NASA proposed or adopted a model rule requiring firms to adopt and maintain business continuity and business transition procedures. The key sort of overriding factor in the model rule is that the type of business continuity plan or business transition plan that a firm must adopt should be based upon the specific facts and circumstances of the particular firm. So NASA recognized that you could have a very wide variation of what type of plans are being adopted by firms depending on their business model, how many clients they have, how many outside vendors they have, whether they are part of a mutual fund complex, whether they offer private funds, whether they have prime brokerage, single custodial arrangements, small firms, big firms, etc. So the SEC proposed a rule in June of 2016, proposed Rule 20644, not yet adopted. Comment period expired some months ago. I don't know if there have been any recent comments, but the thing to keep in mind for purposes of this presentation is that the guidance given by the SEC in proposing the rule is very similar to the written guidance by NASA. So you'll see a lot of similarities between the two rules. So we're going to first cover the NASA rule, both because it was chronologically first and also because there's a lot of easy to use guidance on the NASA website, and so I commend you to that if you want to sit down with some paperwork to help you create your business continuity plan. The NASA guidance is very helpful. This, I believe, we've set forth the rule verbatim. It's very simple. Every investment advisor shall establish, implement, and maintain written procedures relating to a business continuity and succession plan. The plan shall be based upon the facts and circumstances of the investment advisor's business model, including the size of the firm, types of services provided, and the number of locations of the investment advisor. The plan shall provide for at least the following, and you can see the 5 categories that each investment advisor is required to address. And you'll notice this covers both business continuity and succession planning. The SEC uses the word transition planning in place of succession planning, but they're essentially the same concepts. So these are 2 different things. Business continuity being how the firm will continue to service its clients and communicate with regulators and other partners in the case of a significant business disruption, fire, flood, earthquake, terrorist attack, cyber attack, things of that nature. The second part is succession planning. How will the firm continue to provide services to its clients or otherwise arrange for some other person to provide services to its clients in the event of the loss by the investment advisor of some sort of key personnel, be that because of that person's death or disability or something of that nature.
Steve, may I interject?
Absolutely.
Okay. On NASA, I guess the members in adopting this, as you said, we really work with, the state registered, and most of them are small. And in Georgia, for example, most of our advisors, the majority have maybe 1 or 2 persons, in their firm working. So the concern was, especially if there's only 1 person, what happens to the client accounts? What happens, to that business if something, God forbid, happens to that one individual? So that's why NASA moved to this.
Okay. Thank you. And I think that's very helpful and also echoed in the NASA Q&A and other guidance on the website. For example, I know you know this, Nuala, but you can access this by going to nasa.org and then model rules, and you'll see this rule set forth there. And the guidance contains several what they call case studies, and one of at least two of them deal with very small firms. Yeah. So they'll walk you through some of the things to think about if that happens. So these categories that must be addressed by the plan include protection, backup, and recovery of books and records. In other words, having a backup system, a duplication of system, whether that's via a second form of server, over the cloud, offsite record retention, being able to recover the key books and records necessary to continue the business if you lose your primary set of books and records. Second, alternate means of communications with customers, key personnel, employees, vendors, and service providers, and regulators. This includes providing everybody notice of the fact of the business interruption or the death or unavailability of the key personnel. 3, office relocation in the event of temporary or permanent loss of a principal place of business. And Nuala, on this front, I believe that the state regulators have made it clear that in the case of very small advisors, at least for a temporary period of time, it's not necessary, depending on your business model, but you actually have a place like an office in the short term where clients can come and meet, that if it can be effectively done, that you might be able to operate the firm for at least a interim period of time, from remotely from a home office or something like that.
Yes, that's correct. That's accurate.
Now, for the larger firms, that's not very practical because normally you have so many people involved in operations that you would need to get together, and also probably a need to meet more urgently with some clients and vendors at an office. One of the things I'll mention for even the smaller firms, there's always the possibility of monthly rental of meeting locations or small suites of shared office suites. But you have to be careful in that situation, because in the office suite sharing scenario, even on a temporary basis, there can be some significant issues with making sure client data is kept confidential. So if you're sharing office space with another business, that can be much more difficult to keep things under lock and key and out of the way of prying eyes.
Yeah, the key to this, especially on the state level, is how can the client get in touch with you when something happens or disastrous happens. And we found in our experience that when when a client cannot find the advisor, or maybe has learned of an advisor's, death, passing, they'll contact us for help.
Okay. Well, and that leads to another key point of this
Mhm.
point, and it's also emphasized in the SEC rule as well, and that is the advisor has an obligation to tell the regulators as soon as possible. The regulators can provide assistance,
Right.
guidance, or some other form of assistance in terms
Mhm.
of how to mitigate the effects of a business disruption. So the fourth point here is, how are duties going to be assigned in the case of death or unavailability? Who's going to, if the owner who, let's let's take the case of a larger firm. If you've got several advisors and two of them unfortunately perish in a plane crash or something like that, so all of a sudden you've got to reassign those clients. You've got to reassign personnel to meet with those clients, update any forms they may need, get their arms around what the client's immediate needs are to see whether they need to be repositioned or something like that. Even key personnel can even be somebody like your uh, chief information officer who is on a committee that deals with the third party information vendors, because if that person becomes disabled or dies, then you're going to need somebody who'd be able to pick up the duties of that person so that they can carry on the basic operations of the company in that area, make sure that the clients can still access their accounts and submit instructions and return their forms and receive their disclosures and all of that kind of thing. Okay. So again, if you go to the NASA website under model rules, you'll see the commentary we've been speaking about. You'll see the case studies as well as Q&A. Keep in mind that the specific rules that states may adopt could differ from the NASA rules. I'm not quite sure what the statistics are right now on how many states have adopted the NASA rules, but those that haven't yet, and I believe I include Georgia when I say this, Georgia has not adopted it, but they generally consider the rule to be good guidance for firms in fulfilling their fiduciary duties even before the rule is adopted.
Yes, that's true. We have not adopted that yet, although we're moving towards that. However, we do have it as part of our exam. When we go in to do an on-site examination of an investment advisor, we ask them to discuss with us what they have in place should anything happen to the business or to key personnel.
Okay, thank you. So this is sort of echoing what we've already discussed. Think about the idea here is firms need to bring their chief decision makers together to undergo this process of trying to assess what their needs are in this area. So you need to play a little role playing or hypothetical, I guess. Ask what would happen if we lost this person, and this person. And for each person, and we're talking about succession planning right now, determine how the loss of that individual through death or disability or some other means would affect the business. And then you got to decide how you're going to correct the problem or deal with the problem created by that person's unavailability. One of the things that's important to remember, and this goes for firms of all sizes, is you need to think about this on a corporate level. So if someone were to die, how would that impact the corporation's ability to make decisions if it is a corporation? Is it going to, does it cause any sort of dissolution of the corporation? Some bylaws provide that key personnel could cause the corporation to be dissolved, in which case it can't continue any business. And it would be very hard to deal with winding down the affairs of the client if the company itself cannot be in business anymore. You would have several options that would be very difficult to implement, creating a new entity. That new entity would have to register as an investment advisor, or perhaps you would have to look at getting another entity that's already registered to pick up and service the clients. And even transitioning to such a new entity creates a series of challenges, of course, such as are you going to be able to assign the client's advisory agreements with all the issues that are under the state and federal laws surrounding validity of those assignments? Are you going to have all the clients come in and sign new paperwork with that second RIA? So you can see there's a lot of things to consider there. So what this suggests is that you'll want to address this in the corporate or governing documents early on as part of your plan. Put specific provisions in there. If you want the company to continue upon the death of key personnel, that needs to be expressly in your bylaws or your articles of organization or your or operations agreement if you're operating as an LLC. If there are any differences between death and disability, if you want death to be treated one way and disability another, then you should think about those things in advance and make sure they're in the applicable corporate documents. And we've hinted at this next one a little bit already. If you're going to have a successor, another firm will be taking over, you got to make sure that firm has all the licenses, the registrations, that has the capacity to service your clients in the way they're accustomed to being serviced. Do they have the bandwidth, the depth of personnel? Do they have the expertise in the particular type of management that you provide? You need to select a successor very carefully with the idea that they'll be able to continue to provide good service to your clients. One other thing is sometimes there might be consequences to the loss of personnel via contract. This is rare, but it can happen. There might be provisions that say that if a key employee dies, that it might be considered an event of default under a major contract. It might allow people to make claims or accelerate claims for long-term liabilities that they couldn't otherwise accelerate. So you need to consider those kind of contractual provisions as well in coming up with a succession guidelines. Some other thoughts here are, who has access to IRD, who has all the key usernames and passwords and the ability to make filings properly. If that person were to pass away or become disabled, who's going to pick that up? Who's going to interact with the custodian or otherwise rebate fees during the period of time? If that's a key thing that clients expect, particularly if you're going to discontinue service for the client and they're going to be due fee rebates for that reason. Who will deal with creditors and vendors? This next one is very important, and that is non-public personal information. If, as part of your succession plan, your clients are going to end up being serviced by another RIA or some other financial services firm, you're going to need the client's permission in advance to share their personal information with that firm. And so that's the kind of thing that you need to be thinking about getting in either your advisory agreement or some sort of special disclosure and consent form to the client. Whoever you pick to service the client obviously needs to have the proper licenses. And then we talked about the consent to assignment of a contract if you're going to be doing that.
Steve, I wanted to interject on that slide.
Yes.
A recent exam about a year ago, we gave notice of an advisory firm, one-person advisor, that we were coming in to do a books and records and exam, and he disclosed to us that he was terminally ill, had cancer, and probably had less than a year to live from his doctor. So we changed the focus of the exam to be more about setting up some type of succession for his clients, because we discovered he had not told his clients, he didn't want to tell his clients this. But we felt that as you said earlier, that he had a fiduciary duty to his clients to do what's best for the clients, and is to provide a smooth transition should anything happen. So it did take a while, but he, picked an RIA who was probably properly licensed. The clients were notified. He assigned the contracts. The clients moved over. He withdrew his registration, and fortunately he's still with us. But we, like I said, our exam focused on that.
Okay, thank you.
Mm-hmm.
So on the subject of business continuity as opposed to succession, the NASA guidance has a few items that are worth considering. And I don't think I've identified everything that's in the guidance, but these are some points that I wanted to discuss today. Again, part of the business continuity planning involves identifying sort of any type of risk you can think of that might lead to a loss of that might interrupt the business. So there's a few examples listed there, and the one we haven't spoken of much so far in this webinar is the loss of a service provider. So you could experience a major business disruption if your custodian experiences a cyber attack, or some other significant third-party vendor experiences such an attack, or for some other reason loses their ability to perform their services that they provide for both you and your clients. So you should consider those issues as well. And once you've made a sort of a list of all the potential risks you can think of, then that's where you would go under each risk and detail the steps that you would need to take to deal with that particular hypothetical risk. Another thing that you need to do after you have come up with your plan and adopted it as part of your procedures is to decide who needs to be trained and how employees need to be trained to implement the plan should it be triggered. The next thing that is required, and this is expressly required in the SEC proposed rule, as we'll see in a minute, is how do you test this? How do you test the business continuity plan to see if it's going to work? Now, most firms are able to really perform what we usually call a desk test, where they just sort of walk through the scenario and make sure that their redundancies, their backup systems, their secondary employees, their other firms that are going to be stepping in to provide services or products are properly lined up, and that the channels are open to implement the plan once it's triggered. So you should test it once a year, and at least, but once a year is probably deemed sufficient by the regulators, and then document the results of your test. Just say what kind of test we did. We did a desk test. What did we do? We called this person. We checked on this website. We checked our backup system to make sure it was properly backing things up, that sort of thing. Now, that's not to suggest you shouldn't be checking your backup system more frequently than once a year, but that would just be part of the annual testing. How often to update the business continuity plan and how to update it? Well, that should be done at least once a year. And then how exactly you do it would depend on the size of your firm and how disparate your functions, your critical functions, are being conducted by different personnel. But generally, you just need to have all the major decision makers, including your chief compliance officer, involved in how that should be done. These are things we've really already talked about, but I'll skip over some. But client access to funds and securities, this goes along with what Nuala was talking about recently, which was, how's the client going to get in touch with you? Well, you need to make sure they can also get in touch with their money and their securities, whether that's directly to the custodian in situations where you've been serving as an intermediary, or some other way. So redundancies in mission critical systems, this just suggests that you need to have secondary vendors or programs or processes in place for any type of service that's provided to you or to your clients directly. So then in the event one of them goes down, you'll have a backup system. The next one, ensuring redundancy of knowledge within staff. This just suggests that people need to have backup roles in some cases. Maybe employee X is not doing the client invoicing right now, but employee X needs to learn how to do the client invoicing so that if employee Y were to become disabled, then employee X could step in and do it. Clear lines of responsibility for executing the plan. This suggests that somebody needs to be appointed to be in charge of the plan and its execution in the compliance manual. And there needs to be a secondary person, of course, in the event that the person primarily responsible is the one who is unavailable.
Steve?
Yes.
I wanted to make a point about the client access to funds and securities. You will be surprised that how many clients don't know who their custodian is. It's amazing. Some of the calls when they're looking for their advisor, they didn't know that they could go to that document, to their and find the custodian.
Well, that's an interesting point. I mean, particularly in a model such as a hybrid broker-dealer RIA model, where the statements that the client receives might be co-branded, and you might have to look in the fine print to be reminded of who the broker-dealer is down at the bottom. Yeah, so I understand that. So that's a good point. Okay, now we're going to move on to the proposed SEC Rule 20644. The rule is a little bit longer, so I didn't print it verbatim, but it's paraphrased here. And it's very similar to the rule we've been looking at in that it requires firms to adopt and implement a written plan. So again, the plan cannot be just oral. It has to be written, whether that goes for state or SEC. The plan must address business continuity and transition, and the firm must review it for adequacy no less than annually. So again, many of the same requirements we've been talking about. The plan must include policies and procedures reasonably designed to address operational and other risks related to a significant disruption in operations, including, and the two general areas we've been discussing, business continuation after significant business interruption, and the second area, transition of business if the advisor is unable to perform. And then here are the items that the SEC considers essential. These are specifically required by the rule, which has not yet been adopted, but we're expecting it to be. The plan must address the following: maintaining a system of backup and recovery, prearranged alternative physical locations, how to communicate with clients and regulators, must identify and assess critical third-party services, and it must address how to wind down or transfer the business in the event of a cessation of business or a need to transition. Okay, on the next slide, we'll talk about the details of that last one, which are the how to wind down and transfer. These are the things you must consider according to the rule. Considering how to safeguard and transfer client assets. And I would argue that includes client personally identifiable information, private information. Considering how to promptly generate client-specific information for transitioning the clients. Consideration regarding the advisor's corporate governance. So this gets into what we were discussing before about your bylaws, your operating agreement, or some other buy-sell agreement, or some other governing document needs to address what happens in this event. Identification of the financial resources available to the advisor. Is the advisor going to have enough funds to implement the plan, or can it borrow the funds? Is it going to be doable? Can the firm implement the plan given the cost of implementation? An assessment of the law and the contracts, including pooled funds. So this just points again to the idea that if you're going to have to transfer clients to a new service provider, what does that client's contract say about transfer? Are you going to have to comply with the requirements of assignment of the contracts? The SEC rule specifically mentions pooled funds. Is there some provision in the client's limited liability company agreement or partnership agreement that allows the services to be provided by some other general partner or managing member than the one that's currently providing services to the fund? And if you're part of a mutual fund complex, obviously you're going to need some sort of succession plan for the board of directors and other major decision makers for the fund, as well as a succession plan for the investment advisor to the fund. That really concludes our program for today. We have left a little bit of time for Q&A. If anybody would like to ask any questions, this would be a good time to do it. But while we're waiting for you to submit questions, if you have any, let me go back to Nuala and see if she has anything that she would like to add or talk about.
No, I think you've covered it all. Again, from a state's perspective, we're looking at adopting this in Georgia. We feel that it's very important because we do have, I guess, maybe 3/4 of our advisors are one-person firms. And we, feel that there is a duty to the client to have something in place just in case, God forbid, something happened, whether it is a death or a disruption to the business because of a bad storm or, something catastrophic like that.
And Nuala, we know that the SEC is including this area in its regular examination program. Yes. And so is it part of your
yes,
okay.
It is. We right now do not require it by rule, but we do ask about it during the exams.
Okay.
And I do know that some states, I can't remember which states, but I do know several states have officially adopted the model rule. But there are some states out there that had their own, incorporated in their rules. Mm-hmm. And I also know of several states that actually require the submission of the plan prior as part of your registration. Like you have to submit it in addition to other things in order to get registered.
Okay.
Mm-hmm. I do know that. And, unofficially, we've been contemplating that as well here.
I see.
Yeah.
Well, thank you everyone for attending. And again, this will be available on the YouTube channel. We'll be circulating it to another distribution list of advisors who've expressed an interest in seeing it in archived form. If you have any questions for me, please submit those to jsparker@parkmac.com. The email address is shown there on the last slide. I'll be glad to try to answer any question, whether that's about the state rule, the SEC rule. If you have questions that requires any sort of expertise from any of the regulators, I'll try to direct it to the right person. Otherwise, I think we're concluded, and I really appreciate Nuala joining us. It's been very helpful. We appreciate it as always, and we look forward to. All right. Thank you, Nuala. We look forward to speaking with you at a later time.
Thank you.
Bye-bye.